4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Well, welcome to the microphone. Welcome to the studio, Andrew Bell from Bell and Senior Lawyers.
Thanks for having me back, Colin. Talking QCAT today. It's going to be interesting.
We are talking QCAT today. But first of all, I would like to remind the listeners this is a talkback program. This is your opportunity to get some free legal advice live on air. All you need to do is give us a call this morning before 9:30 and preferably well before 9:30. 07 55 20 8888 is the number. And please don't leave it to the end of the show. So we'll kick this one off. QCAT is the topic of the day. And Andrew, most of our listeners have probably never heard of QCAT. What is it?
Yeah, if you've ever heard of things like the Small Claims Court, etc., these all used to be individual tribunals, and in 2009, Queensland combined them together and formed the Queensland Civil and Administrative Tribunal. And because that's a mouthful, everyone refers to it as QCAT.
It is, and every state has one.
They do. It started in Victoria with VCAT, there's NCAT, there's ACAT, obviously, and the interesting thing is that they're not a court, and you can only sue people in them who are actually from that state. So if you do want to sue someone from New South Wales in QCAT, you might have some issues. So
probably a good question to ask, is it the issue is in the state or the person resides in the state?
It's the ordinary residents of the people in the state.
There you go. What sort of things can we deal with in QCAT?
So QCAT, the idea was that it was going to be a faster and cheaper way to resolve disputes without having to use lawyers, that people could have an informal location to have their disputes heard. So it's tenancy disputes, building defects, body corporate arguments, fence and tree line disputes, minor debt recovery, and then there's some other things thrown in, including professional bodies like the lawyers get regulated through QCAT if they have to appeal, or guardianship for people like elderly parents.
So you mentioned that it is, I'm not going to use your words, I think you said it's not like a real court, but the decisions are binding.
The decisions are binding. So it's called a tribunal, and the difference between a court and a tribunal is a tribunal can't make orders, and the people who are making there aren't judges. So if you get awarded money in QCAT, you then have to go to the magistrate's court, and then they will register the order in the court, and it has the power of any other court order.
This is a talkback program. Do not leave it to the end of the program. We'd love to hear from you. Get some free legal advice right here, right now. 07 55 20 8888. All right, give me a real Gold Coast example. What kind of problems end up at QCAT?
So if you're a renter and your landlord won't return your bond, then you can go to QCAT. If you're a homeowner and you've paid money for a kitchen renovation and the work was defective, again, you can go to QCAT. If you're in a high-rise and the body corporate's blocking you from doing something, you may have a claim in QCAT. If someone backed into your car and you're not insured and they're not insured, again, it might be a minor claim in QCAT. If you have a tree that's dropping branches or a fence that's falling down, again, you're going to QCAT.
So it's a great little opportunity to get things done, and we'll move to the next bit. Is this something that is easily done, or is it a process involved?
So it is a process. It's less involved than a court process, and they're able to be more flexible in terms of rules around evidence, etc., that you would otherwise have in a court. So it's designed for people who don't know what they're doing and don't do this every day. You fill in a form, you make sure that it gets to the other side. They've now moved that online, so you don't even need to go into the registry to file the paperwork. They may give you a hearing for a mediation where you can talk about your problems with a professional problem solver to try and have it solved. Otherwise, you can have a hearing.
All right. Is it actually faster than court? Because everything with the legal system seems to be forever, doesn't it?
It does. And unfortunately, when QCAT came out, it was very fast. According to their own website that I checked this week, tenancy disputes are running at about 28 weeks, consumer disputes about a year, and building disputes can be nearly 2 years. So it's not in for the long haul. It's not in for the short time. However, if you are using the magistrates' court, you're going to be looking at similar or longer times.
All right. Well, we are talking QCAT this morning, but that doesn't preclude any legal question. We'd love to hear from you. It is a talkback program. 0755 20 8888. We've got our first caller. Very good morning to George. George, ask your question of Andrew.
Oh, hello, Andrew. My question is to do with a fence.
Yep. Go ahead, George.
Now, not so long ago, my neighbour put up a very long and quite expensive fence, and he paid for the whole lot, right? Which I appreciated. Now, about 8 months after that, a tree on my property fell during a storm and demolished a good part of the fence. And now he came to me and said, because he paid for this fence outright, he said to me, you know, your tree caused it and you need to pay for it. Well, I would have anyway, regardless whether I was in the right or wrong, because he did pay for the fence, and I thought, well, that's the least. But now, did I have to do that? Because I'm worried about this happening again, and I'm not going to keep doing it. But he said to me, you have to fix it, And I said, well, whether I have to or not, I'm going to, because, you know, that's the neighbourly thing to do. He paid for that fence. And I did pay for it to have repaired, and it's as good as gold. But my question now, it's all done and dusted, but I'm just thinking, did I have to, or would I have to do that again, or what's the story there?
So there's two questions here. One's the question of liability, about who's the responsibility for the fence being damaged. Yeah. If fences are just falling down, Queensland has something called the Neighbourhood Dividing Fences Act. And under that, neighbours, if they wish, must be able to have what's called a sufficient fence. So if it was elaborate and made out of brick, you may have been able to replace it with a wooden fence as being sufficient, and you would only be liable for the costs to put up that sufficient fence. However, if your side did cause damage to the fence and the fence required replacing because of an act of yours and the fence was properly maintained, then you probably would have been found liable, at least to the extent that you're required to fix the fence. So, yeah, I think you did the right thing. I think you probably would have been found that you needed to repair the fence.
Well, the fence it's a very long fence. It was a colour-bond fence, and it couldn't have been patched up with anything else. We had to replace the section that was damaged so it could be consistent, you know. So it wasn't replacing the whole fence. But because the tree was on my property,
you're typically responsible for the trees that are on your side of the fence. So if it fell down, then typically you'd be responsible for the damage that they caused.
Okay, even if the trees came down by natural disaster like storms and...
Typically that's the case. There may be some other evidence that might change things, but typically if it's your tree doing the damage, you're deemed to have done the damage.
Okay.
Same if the roots of your tree are damaging their pool or other bits and pieces, those have also been found to hold people liable.
Okay. So if it happens again, I was going to say if it happens again, well, it's not my fault, but so I would be, if he pushed the matter, I would be responsible for that.
That's likely to be the case, George.
Yeah, okay. I appreciate your help. Thank you very much.
No worries.
Good on you, George. Thank you for your call. All right, we're moving on now to Diane. Diane, ask your question of Andrew.
Yes. Hello, Andrew. Thank you very much for taking my call.
Hi, Diane.
My daughter-in-law's mother, she's still alive, but she's told me that she has excluded my daughter-in-law and her son from her will, and the daughter-in-law was in a previous will. So, yeah, the mother's still alive. But what are the chances of appeal? Because she said, I have sewn it up so tight that they'll have to go to court in front of a judge to get anything. So there was some previous monies given, $100,000 to both daughters, nothing for the son. So whether that's her ending, that's all you're getting. The estate is around $4 million.
So, Diane, in Queensland, people need to be adequately provided for under a will, and if you're part of a relevant relationship, such as the son or daughter of someone, then you're entitled to make a claim called a family provision claim under the will. Now, it is correct that you would have to do that through court. You don't have automatic right to be able to just siphon a portion of money off without all the beneficiaries agreeing or without a court order. However, it all depends on the personal circumstances of both the person who's saying they weren't adequately provided for and the circumstances of everyone else who received a gift. So in those circumstances, I would recommend that you get legal advice. And there's nothing you can do until she has passed. However, the other thing to consider also may be her capacity to make these decisions. That's often how these things get appealed, is that the person making the will may not have been of their right mind when they made that decision, and any earlier terms of any earlier wills may be taken into consideration. But that's a question of evidence that would have to go before the court.
Yes, right. Thank you so much for your help.
No worries. Thank you, Diane.
Thank you, Diane. All right, we are now moving on to Sue. Sue, good morning to you. Ask your question of Andrew.
Good morning, Andrew. It's Sue here.
Hi, Sue.
I'm just inquiring as to whether a next of kin is entitled to a copy of a will.
Okay, well, that's an interesting question. Is this, has the person died for the matter of the will?
The person has died, yes, and I'm the oldest surviving sibling. He has no wife and no children, so I am therefore deemed to be the next of kin.
Okay, and there is a will in place?
Sorry?
And there is a will in place?
There is a will, yes.
Who is the executor of the will?
His niece.
Okay, so typically the people who are able to get a will, if it's in probate in the court, you can apply to the court to get a copy. Normally you would contact the executor, and normally they would be provided by anyone who's a beneficiary, so someone named in the will, anyone who was named in an earlier will, anyone who's an executor or administrator, typically family members or people with those relationships we talked to the previous caller who might have a right to claim under the will. So being next of kin, I would think that you have a strong case to be able to ask the executor for a copy of the will.
Okay, thank you so much.
No worries.
Good on you, Sue. Thank you for your call. Now, we did have Rod. Rod, you've dropped out. If you'd like to give us a call back, we'd love to hear from you. And if you all have a question for Andrew from Bell and Senior Lawyers, you can give us a call right now, 0755 20 8888, and we'll just go to a message from our sponsor.
Wills, probate, powers of attorney or property matters. Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 3133 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
All right, if you'd like to ask a legal question of Andrew Bell from Bell and Senior Lawyers this morning, now is your time. We're in the final 12 minutes of the program. 0755 20 8888 is the number. We'll go back to our topic of the day. We've been talking QCAT and who is a typical user, business or everyday people?
So QCAT is, unlike the court system, which is taken up by lawyers and businesses, QCAT's overwhelmingly everyday people. So the biggest category is residential tenancy disputes. Gold Coast, where you have a very large rental population. So disputes around bonds, damages and forcing repairs. And that reflects our demographics. Second is minor debts. So chasing anything up to $25,000, people have very great difficulty getting paid, and QCAT's a way you can do that. And the third biggest category is consumer disputes. So if you paid for something that wasn't delivered or was defective, you can actually take a business to QCAT and have your day trying to solve this dispute in a tribunal.
There you go. Well, that sounds fairly easy. We've got a few more questions to come along, but we'd like a question from you. 0755 208888 is the number. 10 minutes left in the program. Do not leave it too much longer, otherwise you will not get your question to air. All right, if I win at QCAT, do I get my legal costs back?
Okay, so this is one of those distinctions again between the tribunal and the court, Colin. So the costs aren't high, but you don't get your costs back. So QCAT operates on what they call an own costs rule. Each party pays their own legal costs regardless of who wins. So in a court, typically if you win, you can apply for costs and have some or all of your legal fees paid back. In QCAT, that's not the case. However, as we said, the intention is that people are doing QCAT for themselves. There is a filing fee, depending on the matter, can go from about $60 to about $300. And if you're in a hardship like a pensioner, you can even apply to have that waived. But if you do engage someone to help you, or you do have costs to go to QCAT, you then need to look at the financial reality of going. If you're looking for $5,000 and you're going to spend $3,000 getting everything prepared to go to QCAT, and you're not guaranteed a win, it may not actually be a sensible decision.
Yeah, okay, that's fair and just. All right, we have our next caller. It is a very good morning to Amanda. Amanda, ask your question of Andrew.
Good morning, Andrew. My question is, I had my bin out on my front yard, and my gardener came and he moved the bin and put it on the driveway, but he didn't tell me that he put it on the driveway, and I backed my car out and hit the bin and it cracked my car light. So I'm just wondering who's responsible to fix the light.
It's an interesting question. It depends. This is a tort question, and potentially it's a negligence question. So you would have to look at, so the tribunal or whoever was looking at this would need to look at it and say, if the bin wasn't left there, would the damage have occurred? And also look at, should you have seen the bin when you were reversing, and do you have any negligence on your own behalf? My feeling would be is to contact them and ask them nicely to pay for the damage on the basis that they shouldn't have left it there and it was a hazard. But legally, I think you're probably 50-50 whether you would actually get a decision in your favour or not, unfortunately.
Right. Yeah, because when I was backing out, he was there beside the driveway and it was very noisy because he had the whippersnipper, and I was making sure that I wasn't hitting him. And I didn't realise that the bin was on the driveway, so I just wondered, yeah.
Well, normally if someone leaves something that's a hazard, the question is the but-for test. But for that happening, would the accident have occurred? Well, you can say if the bin wasn't there, the accident wouldn't have occurred. However, you then need to say, would an ordinary person have actually been looking for the hazard? Would it have been visible? Would the person who left it there known that? So, as I said, I would be contacting them and asking them kindly to pay for the damage on the basis that they shouldn't have left it there and they knew that it was a busy traffic area. But if you did take it to a tribunal, etc., as I said, I'd give you about 50-50 odds of you walking away, getting them to pay for it.
Okay. And is that something that's covered by their public liability insurance?
It could be. Oh, sorry. For the coughing. It could be, however, I would bank on the insurance company sending you a letter saying that they don't deem that they've covered this particular incident.
Right. Okay. So they wouldn't normally cover something like that.
Well, insurance companies typically write letters to people saying that we don't believe that our insured client was at fault, and I think there's enough here for them to validly say that. Okay.
All right. Thank you very much for your help.
Good luck.
Thank you, Amanda.
Thank you.
All right. Well, if you'd like to ask a question just like Amanda did, we're in the final 5 minutes of the program. Do not leave it any longer. 0755 208888 is the number. The but-for rule, Andrew. So that was an interesting one. You used it in the last phone call.
Okay, so negligence is an interesting area of the law because most other areas relate to something directly happening that you're responsible for. If I punch a window and break it, I'm directly responsible for it. If I have a contract and it says you must do this, I'm directly responsible for that. Negligence law came out of the fact that bad things happen to people that weren't necessarily intended. So negligence law relates to if I do something and someone else gets injured or something gets broken as a relation of it, am I liable or am I not liable? And there is a series of legal tests involved in negligence law to see if you are actually responsible. And so one of those is the but-for test. If you can't establish, just because something bad happened doesn't mean that someone's liable, no matter how much you want them to be. The but-for test is one of those things. If that action from that person didn't happen, would the negative result still have happened or not happened? If you can't make that out, then that person isn't liable.
Gotcha.
If you can make that out, there's all sorts of other tests. For example, is there a duty of care? So a duty of care is a term we hear a lot. If you've got children, etc., you're often hearing about whose duty of care. Mechanics. So there is a set of established duties of care that people owe. So parent-child, teacher-student, mechanic, and the owner of the vehicle that they're repairing are all long established duties of care. So if you fit into one of those duties, it's all good. Otherwise, you then need to establish, does the person who did that thing for the but-for ordinarily owe a duty to the kind of person that was injured? So negligence has about 5 tests. We can go through them on another show.
Yeah, it was an interesting one, and I'm a big fan of the golden rules where you can just pop a one-liner out like I before E except after C, and 9 times out of 10 you can measure whether you're on the right side or the wrong side. So it's a nice, neat one.
Well, I typically start with the but-for. But for them leaving that there, would it have happened? But for the tree falling on the fence, would the fence have fallen over? If you can say these things would have happened anyway, then it's very difficult to hang someone for that.
All right, last couple of minutes of the program, we'd love to hear from you. 0755 208888. All right, moving on and back to QCAT.
I might talk about one of the things that comes to me at my community legal when we're giving advice there. And this is probably the most common scenario. Someone sues someone in QCAT and they just don't reply. So you fill in the paperwork and you pay your application fee and you have a QCAT case. You then need to serve, you need to get the documents to the person, and then you need to write back to QCAT to say that person's served. Once you do that, you've got 28 days for the other side to put in a reply. Most of the time, my experience is people don't reply to those QCAT documents. Either they don't know how to, they put it off, they don't read that there's a time limit.
Bury your head in the sand.
Bury your head in the sand. It is possible after that 28 days to go back to QCAT and file for something called a default judgment. It's a form, you fill it in, you say, here's how service was done, here's all the information that I put in my initial claim. It will then get reviewed by a tribunal member who will then decide whether it had merit, and if it had enough merit and they hadn't replied, then they make a decision in your favour automatically. So if you're going to QCAT, remember default judgment.
Oh, that's very interesting. All right, we're moving on. The last phone call just got in by the bell. Good morning to you, Sarah. Sarah, ask your question of Andrew.
Yes, good morning. Good morning, Andrew. My quick query is a neighbour's tree branch falls on my roof. Who's responsible for the damages?
Prima facie, it's them. If it wasn't maintained properly and it's hanging over the boundary and damage resulted from their tree, and that is also something you can take to QCAT. Look at the neighbouring dividing fences and neighbouring trees legislation.
Okay, that's great. Now, it's clear for me. Thank you.
Thank you.
Good on you, Sarah. Well, thank you very much for your question. Well, we've got a minute and a half left, Andrew. I thought we might wrap it up with a bit of a summary.
Thank you, Colin. So, as I said, today we've talked QCAT, Queensland Civil and Administrative Tribunal. I didn't mention that it's potentially online, or there's one at Southport at the courthouse. It's for all of your things most things under $25,000 in residential tenancy disputes. It's set up so you can try and handle things yourself, but you can reach out for help if you need it. So don't be afraid of QCAT. Don't be afraid if you've got a dispute and you do the research online and you think you've got a case, or speak to a community legal centre to consider QCAT as an option going forwards. Great information this morning, Andrew. Thank you very much for your time. Thank you all very much who called into the show and posed your questions. They add to the show and add to the information we provide. Andrew Bell from Bell and Senior Lawyers, thank you very much for your time this morning. Thank you, Colin. Talk to you next week.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.